We will commence, madam. Kindly unmute yourself. You are a co-host, Allah. One minute. I think you can do it. 1 minute. Now you are the co-host now. You can't unmute?
Yeah, I can now. Can you hear me? Yeah. Okay, are we good?
Let me see whether I can see you. Yeah, I can see you. Okay.
Yes.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಹಾಗೂ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಲಾ ಅಕಾಡೆಮಿ ಇವರು ನಡೆಸುತ್ತಿರುವ ಜಿಲ್ಲಾ ನ್ಯಾಯಾಧೀಶರ ಮುಖ್ಯ ಪರೀಕ್ಷೆಯ ಅಂತರ್ಜಾಲ ತರಬೇತಿ ಶಿಬಿರಕ್ಕೆ ತಮಗೆ ಸ್ವಾಗತ. ಇಂದಿನ ಉಪನ್ಯಾಸಕರು ಶ್ರೀಮತಿ ಎಸ್.ಆರ್. ಅನುರಾಧ, ಹಿರಿಯ ನ್ಯಾಯವಾದಿಗಳು, ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ. ತಮಗೆಲ್ಲರಿಗೂ ಶುಭ ಕೋರುತ್ತಾ ಶ್ರೀಮತಿ ಅನುರಾಧ ಇವರನ್ನ ಉಪನ್ಯಾಸ ನೀಡಲು ಕೋರುತ್ತಿದ್ದೇನೆ. ಧನ್ಯವಾದಗಳು. You can yes.
I can start. All right. And am I audible?
Yes, madam. Yes.
Okay. Good evening to one and all. So today I've been asked to speak on Constitution of India. It is such a big document, a living document, almost like more than half of our Bhagavad Gita. And that I'm supposed to finish it in a very short time. So it's a big onerous job for me, but I hope that I will be able to bring you those essential features of the Constitution, which will help you to answer the paper that you are going to do in a few days. So before I start with the talk, let me first take this opportunity to thank the President and all the office bearers of the Karnataka Bar Council and Bar Council Academy for giving me this opportunity. And I also seek the blessings of my seniors in giving this talk. This talk I have structured that I will elaborate on Preamble, Article 13, 14, 19, and 21. And then maybe some other basic structure of the Constitution. And if time permits, then we will touch upon other fundamental rights. Then we will do some direct principles of state policy and then fundamental duty. So we will take it on from there. I have made a PPT for you so that you can understand it better and see. I'll try to speak first in English and maybe try to cover it or sum it up in Kannada so that ಎಲ್ರಿಗೂ ಅರ್ಥ ಆಗುತ್ತೆ ಅನ್ನೋ ಒಂದು ದೃಷ್ಟಿನಲ್ಲಿ. I have two caveats that I want to put before I start. One is that Constitution to all of us or to me is more of a philosophy. ಒಂಥರ ತತ್ವಜ್ಞಾನ ಇದ್ದಂಗೆ. It is a living document and it has evolved over these 75 years that we have seen the Constitution getting evolved. So the number of cases that are there are like huge. So I am not going to divert your attention by going through like large text of cases. So try to make an effort to bring it as concise as possible. But since it is a philosophy, I could be possible that I may just get kind of carried away. So we will try and not get diverted and then be within the course. With this, I would like to begin and I will do a small PPT sharing for you. Okay, is it on for everyone?
Yes, I can.
Yes. Okay. So ಭಾರತದ ಸಂವಿಧಾನ ಇದ್ರದ್ದು ಒಂದು ಸಣ್ಣ ಹಿನ್ನೆಲೆಯನ್ನು ನಾವು ನೋಡೋಣ. ಸೊ ಬ್ರಿಟಿಷರು ನಮಗೆ ಇಂಡಿಪೆಂಡೆನ್ಸ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದಾಗ we brought in an act called the Indian Independence Act of 1947. Now this act essentially provided for setting up of a constituent assembly. Now this constituent assembly was a group of people or politicians who would essentially carry on the running of the country until an election took place. So the Constituent Assembly will be the governing body for the independent India, as you can see. One of the members of this Constituent Assembly, we should be proud, was our Chief Minister Kengal Hanumanthaya. And this Constitution Committee constituted a Constituent Assembly constituted a Constitution Committee. Now this Constitution Committee was headed by Dr. Ambedkar. And then another Kannada luminary called Benegal Narasimha Rao. He was the first person who gave a draft of the Constitution as we have it today. And this was deliberated over a period of 3 years. And then it stood adopted on 26th November 1949. And then it thereafter came into force on 26th January 1950, which aspect I think as lawyers we all should know. The preamble of the Constitution starts something like, we, the people of India, solemnly resolve and constitute India into a sovereign democratic republic. So this was what was there in the initial Constitution. So let's look at this first. So sovereign andreno sarvabhaumatva antana helbodu. Iga nammalle madlu British iruvaga we had a sovereign was the Queen of England. But now independent admele idi territory goskara we the people were the sovereign, no one else. So we didn't have anyone else who were ruling us. So in that sense, we became a sovereign country. ಈಗ ಉದಾಹರಣೆಗೆ ಹೇಳ್ಬೇಕಂದ್ರೆ Australian country, Australia has a constitution. ಅವರಿಗೊಂದು constitution ಇದೆ. ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇದ್ರೂ ಸಹ, though they are also democratic, they owe their allegiance to the Queen of England even now. So in that sense, we are a sovereign country and not ruled by any sovereign. Then democratic, ಎಲ್ಲರಿಗೂ ಗೊತ್ತಿರೋ ಹಾಗೆ ಪ್ರಜಾಪ್ರಭುತ್ವ. What is the form of the government that we adopt is a universal adult franchise. Everybody has a choice to vote. Now, ಇಲ್ಲಿ ಒಂದೆರಡು ಮಾತುಗಳನ್ನ ನಾವು ನಮ್ಮ ಗಮನದಲ್ಲಿ ಇಟ್ಕೊಂಡಿರ್ಬೇಕು. When the American Constitution came into existence, not all of them had a power to vote. Thereafter, they made amendments to that. So we were lucky that the first time when we had a constitution, everyone had a right to vote. Everyone above 18 it was, now it has been made to 21. When prior to this constitution, people who could vote were only either graduates or people who paid income tax in India. Only they were allowed to. So with this, you can see that truly we are a democratic country where every citizen of the country is allowed to vote. Next, we are known as a republic. Republic andre enu? Ganarajya. So we do not have any king or anyone ruling ourselves. We have a constitutional head who is person who is chosen by the parliament or appointed to the post, and then he becomes the head of the all the three wings, and therefore he is like, we are more of a presidential Westminster concept of both a prime minister and a president. You know, in 42nd amendment, we had two aspects. One was socialist and secular. These two were added in the constitution. Socialist annodu samajavadi. It's again a concept of ruling ourselves. Ellerigu ಒಂದು ರೀತಿಯಾದ ಸಾಮಾಜಿಕ ಮನ್ನಣೆ ಅಥವಾ ಸಾಮಾಜಿಕ ಈಕ್ವಾಲಿಟಿ ಅನ್ನೋದ ಇರಬೇಕು ಅನ್ನುವಂತ ಒಂದು ಸೋಷಿಯಲಿಸ್ಟ್ ಕಾನ್ಸೆಪ್ಟ್. ಸೆಕ್ಯುಲರ್, this concept would only mean that the state will not follow or have any religion. It will respect all religion, but it will not give any preferential status to any one religion. So this is the concept of secular. So now our constitution preamble reads sovereign, secular, socialist, democratic republic. So India is all of this. Then next part of the preamble is India has now given to its citizen, that is any government that comes, it will give to its citizen justice, liberty, equality and fraternity. So ಒಂದೊಂದಾಗಿ ಬೇಗ ನೋಡ್ಬಿಡೋಣ. ಜಸ್ಟಿಸ್ ಅನ್ನೋದು ನ್ಯಾಯ. ಈ ನ್ಯಾಯ ಬರೀ ಕೋರ್ಟ್ ಕೊಡುವಂತ ನ್ಯಾಯ ಅಲ್ಲ. ಒಂದು ಸಾಮಾಜಿಕ ನ್ಯಾಯ, ಆರ್ಥಿಕ ನ್ಯಾಯ ಆಗಿರ್ಬೇಕು, ಮತ್ತೆ ಒಂದು ರಾಜಕೀಯ ನ್ಯಾಯ. ಇದೆಲ್ಲನ್ನು ನಾವು ಇದು ನಮ್ಮ ಗುರಿ. ಎಲ್ಲಾ ನ್ಯಾಯನೂ ನಾವು ಅದನ್ನ ಅಚೀವ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋಂಥದ್ದೇ ಈ ಅರ್ಥ. ನೆಕ್ಸ್ಟ್ ಲಿಬರ್ಟಿ, ದಟ್ ಇಸ್ ಸ್ವಾತಂತ್ರ್ಯ ಅಂದ್ರೆ ಏನು? ಇಟ್ ಇನ್ಕ್ಲೂಡ್ಸ್ ಬೋತ್ ಪರ್ಸನಲ್ ಲಿಬರ್ಟಿ ಅಂಡ್ am I audible?
Yes madam.
Yes, sorry. So ಪರ್ಸನಲ್ ಲಿಬರ್ಟಿ ಮತ್ತು ಪಬ್ಲಿಕ್ ಸೇಫ್ಟಿ ಎರಡುಗೆ ಬ್ಯಾಲೆನ್ಸ್ ತರುವಂತದ್ದೇ is called as liberty. So there should be liberty of thoughts, expression and religious belief. So that is the concept of liberty. Now equality ಅನ್ನೋದು ಸಮಾನತೆ. So this ಸಮಾನತೆ should be of ಅಂತಸ್ತು ಮತ್ತು ನಮ್ಗೆ ಏನೇನು ಅವಕಾಶ ಸಿಗುತ್ತೋ ಇದೆಲ್ಲದರಲ್ಲೂ ಒಂದು ಸಮಾನತೆ ಇರಬೇಕು ಅನ್ನುವಂಥ ಒಂದು ತತ್ವ ಇದೆ. ನೆಕ್ಸ್ಟ್ ಫ್ಯಾಟರ್ನಿಟಿ ಅಂತಂದ್ರೆ ಏನು? ಭ್ರಾತೃತ್ವ. ಇಡೀ ದೇಶವನ್ನ ಅಥವಾ ನಮ್ಮ ಇಡೀ ಭಾರತವನ್ನ ಒಟ್ಟುಗೂಡಿ ಇರೋಕ್ಕೆ ಈ ಒಂದು ಭಾವನೆ, ದಿಸ್ ಇಸ್ ಮೋರ್ ಆಫ್ ಅ ಇಮೋಷನ್. ಸೊ ಈ ಒಂದು ಭಾವನೆಯಿಂದ ಜನರು ಇರಬೇಕು ಅನ್ನುವಂಥ ಗುರಿನೇ ಫ್ಯಾಟರ್ನಿಟಿ ಅನ್ನೋದನ್ನ ನಾವು ಅದನ್ನ ಹೇಳ್ಬೋದು. ಈಗ ನಿಮಗೆ ಪ್ರಶ್ನೆ ಮೋಸ್ಟ್ಲಿ ಕ್ಲಾಸ್ ಅಲ್ಲಿ ಎಕ್ಸಾಮ್ ಅಲ್ಲಿ ಏನ್ ಬರ್ಬೋದು, ವಾಟ್ ಇಸ್ ದ ಪ್ರಿಯಾಂಬಲ್ ಆಫ್ ದ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಂತ ಕೇಳಿದಾಗ ನೀವು ಈ ಎಲ್ಲಾ ತತ್ವಗಳನ್ನ ಬರೆದು ಇದಕ್ಕೆ ಏನು ಅರ್ಥ ಅನ್ನೋದನ್ನ ನೀವು ಹೇಳ್ಬೇಕಾಗುತ್ತೆ. ಈಗ ಇದನ್ನೆಲ್ಲ ನಾವು ಈಗ 10 ಮಾರ್ಕ್ಸಿನ ಪ್ರಶ್ನೆಗೆ ಜ್ಞಾಪಕ ಇಟ್ಕೊಳ್ಳೋದು ಹೇಗೆ ಸಾಮಾನ್ಯ ಮನುಷ್ಯರಲ್ಲಿ ಕಥೆಗಳು ಹೇಳಿದ್ರೆ ಅವರು ತುಂಬಾ ಚೆನ್ನಾಗಿ ಜ್ಞಾಪಕ ಇಟ್ಕೊಂತಾರಂತೆ. ಇದಕ್ಕೊಂದು ಕತೆ ಇದೆ. ನಿಮಗೆ ಪ್ರಿಯಾಂಬಲ್ ಅಂತ ಪ್ರಶ್ನೆ ಬಂದಾಗ ನಿಮ್ ಮನಸ್ಸಿಗೆ ಬಸವಣ್ಣನವ್ರು ಬರ್ಬಿಡ್ಬೇಕು. ನೋಡಿ, 12ನೇ ಶತಮಾನದಲ್ಲಿ ಅನುಭವ ಮಂಟಪ ಅನ್ನುವಂತ ಸ್ಥಾಪಿಸಿದಂತವ್ರು ಬಸವಣ್ಣನವರು. ಅಲ್ಲಿ ಚರ್ಚೆ ನಡೆದಿದ್ದು ಈ ಎಲ್ಲಾ ವಿಷಯಗಳ ಬಗ್ಗೆ. ಎಲ್ಲರಿಗೂ ಸಮಾನತೆ ಇರಬೇಕು, ಎಲ್ಲರಿಗೂ ಸ್ವಾತಂತ್ರ್ಯ ಸಿಕ್ಕಿರ್ಬೇಕು. ಅವರು ಬಿಜ್ಜಳ ದೇವನ ಆಸ್ಥಾನದಲ್ಲಿ ಮಿನಿಸ್ಟರ್ ಆಗಿರ್ತಾರೆ. ಒಂದು ಅಂತರ್ಜಾತೀಯ ವಿವಾಹ ನಡೆಯುತ್ತೆ. ಬಿಜ್ಜಳ ದೇವ ಗಿವ್ಸ್ an order to behead both who would have got married. So he then leaves from there and then he goes and starts this. ಈ ಅನುಭವ ಮಂಟಪ ಅಂದ್ರೆ nothing but a parliament of the 12th century. ಅದರಲ್ಲಿ ನೀವು ಅವ್ರ ಬಗ್ಗೆ ಯೋಚನೆ ಮಾಡಿದ್ರೆ ಅವ್ರು ಏನೇನ್ ತತ್ವವನ್ನು ಮಂಡಿಸಿದರು ಅದನ್ನ ಎಲ್ಲಾನು ನೀವು ನಿಮ್ಮದೇ ಆದ ಒಂದು ಲ್ಯಾಂಗ್ವೇಜ್ ನಲ್ಲೋ ಅಥವಾ ಕಾನ್ಸೆಪ್ಟ್ ನಲ್ಲೋ ಅದನ್ನ ನೀವು ಬರೆದ್ರೆ ಅದೇ ನಿಮ್ದು ಅದರ ಪ್ರಿಯಾಂಬಲ್ದ ಒಂದು ಆನ್ಸರ್ ಆಗುತ್ತೆ ಅಲ್ವಾ. ಸೊ ದಿಸ್ ಇಸ್ ವಾಟ್ ಇಸ್ ಪ್ರಿಯಾಂಬಲ್ ಆಫ್ ದ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್. ಸೊ ನೆಕ್ಸ್ಟ್ ನಾವು ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ ಅನ್ನೋದಕ್ಕೆ ಹೋಗೋಣ. ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ ಆರ್ ದೋಸ್ ಬೇಸಿಕ್ ರೈಟ್ಸ್ which the person has and can enforce it through a state, through law against the state in the court of law. So what are these fundamental rights? Before that, let us see three aspects in this. One is, of course, basic law, basic rights. Two is a state. It is against the state that you enforce these fundamental rights. And with what? With the laws, if there is any law which affects these fundamental rights, then you can question these laws and claim your fundamental right. Therefore, we need to see what is state before we go into the fundamental rights itself. State ಅನ್ನೋದನ್ನ Article 12 ಅಲ್ಲಿ define ಮಾಡಿದ್ದಾರೆ. What is a state? Now, state is a government which enforces again, or rather protects the fundamental rights of every, not only citizen but also of the resident. So ಈ state is more of a inclusive definition. So ಈ state ಅಲ್ಲಿ ಯಾರ್ಯಾರು ಬರಬಹುದು ಅಂತಂದ್ರೆ ಅದನ್ನೇ ಅಲ್ಲಿ definition ಅಲ್ಲಿ ಇಲ್ಲ, but over a period of time through court decisions we've had to say that of course government and Parliament of India is a state. Then we have all state legislatures and governments are state. Then we have local authorities. Then we have other authorities which come within the territory of India or which are under the control of the government of India or state government. Then you have statutory bodies which are wholly or partly owned by the government. All these become a state in the Article 12 of the Constitution. ನಿಮ್ಮ ಪ್ರಶ್ನೆ ಏನಾದರೂ what is state? Please define. ಅಂತಂದ್ರೆ you will have to write ಇದು ಒಂದು inclusive. State means and includes the government of the day. It includes the legislature which passes the laws and all other local authorities and boards which are constituted or come into existence because of a statutory or a statute. Or any companies which are owned by the government either semi or partially or fully. ಈ ರೀತಿನ ನೀವು ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಬರೆದ್ರೆ ಈ ಡೆಫಿನೇಷನ್ ಆಫ್ ದ ಸ್ಟೇಟ್ ನ ನೀವು ಆ ರೀತಿ ಉತ್ತರ ಕೊಡಬಹುದು. ನೆಕ್ಸ್ಟ್ Article 13, laws inconsistent with or in derogation of fundamental. ಹೇಗಂದ್ರೆ so they said that any law which was already in existence makes a law which was already in existence void if it is inconsistent with the Constitution. So ಮೊದಲು ಬ್ರಿಟಿಷ್ ಅವರು ಏನೇನು ಕಾನೂನು ಮಾಡಿದ್ರು ಅದೆಲ್ಲ ನಮ್ಮ ಸಂವಿಧಾನದ ವಿರುದ್ಧವಾಗಿದ್ರೆ ಅದರಷ್ಟಕ್ಕೆ ಎಷ್ಟುವರೆಗೂ ಅದು ವಿರುದ್ಧವಾಗಿದೆಯೋ that much only becomes void. Plus all future laws which are against the or in violation of the fundamental rights, are they to be struck down was slowly talked about as we go through. So essentially law here means all the laws made by the legislature in its in its legislative power. So what are these laws? So 13.3 says this can be any executive order, it can be any enactments, bylaws, rules, regulations, notifications, even customs and usages having the force of law are also laws under Article 13 of the Constitution. Then from I will idana ನೀವು now ನಂತರ ನೋಡೋಣ. ಈಗ for 13 ಪ್ರಶ್ನೆಗೆ what is the law under the constitution ಅನ್ನೋ ಪ್ರಶ್ನೆಗೆ ಆ ರೀತಿ ಏನಾದರೂ ಪ್ರಶ್ನೆ ಬಂದ್ರೆ the law constitution are the laws made by the legislature. They include an executive order, an enactment, bylaws, rules, regulations, and even customs which has the force of law ಅನ್ನೋದನ್ನ ನೀವು ಬರಿಬೇಕಾಗುತ್ತೆ. Then the laws, which are the laws that become void? All existing laws which are in violation of the fundamental rights become void to that extent. So next, Article 14. Now, what does 14 say? State before law and equal protection of law. So, idalli more elements ide. One is equality before law, and it is applicable to every resident or any person and need not be restricted only to a citizen. Ee ondana neevu gamanadalli itkondirbeku. That is one of the essential features of Article 14, because some laws are only for citizens, some fundamental rights are for everyone including citizens. So ee ಒಂದು ಅಂಶನ ನೀವು ಗಮನದಲ್ಲಿ ಇಟ್ಕೋಬೇಕಾಗುತ್ತೆ. So equality before law ಅಂದ್ರೆ ಏನು ನೋಡೋಣ. Equality before law was a concept which is based in somewhere in the 12th century in England, where prior to that the king assumed the supreme power. He said nobody is above me. So there was some kind of a revolution that was going to happen. So they brought about a unwritten constitution, which is called the Magna Carta. Magna Carta essentially says that the law is above the king. And so they made certain rules to say that the king will also be abiding by these rules. So this concept of no one being above the law and the law being supreme and everyone who comes before the law are the same. Whether it is government, president, the government. ಇದು ಆಧಾರಿತ ಮೇಲೆ concept. What is that? Concept that came as an offshoot of rule of law. So in order to explain rule of law, ಇಲ್ಲಿ ನೋಡಿದ್ರೆ ಇದು ನ್ಯಾಯ ದೇವತೆ, ಇಲ್ಲಿ ಅವ್ರ ಮುಂದೆ ಬಂತವರೆಲ್ಲರೂ ಸಮಾನರು ಅನ್ನುವಂತಹ ಒಂದು ಪ್ರದರ್ಶನವನ್ನು ನಮ್ಗೆ ಇಲ್ಲಿ ಕಾಣಿಸೋಕಾಗ್ತಾ ಇದೆ. ಸೊ ನಾವು ನೋಡ್ತಾ ಇದ್ದೀವಿ ಇದನ್ನ. ಸೊ therefore rule of law or equality before law is nothing but every person is equal before the eyes of law. ಈಗ ಈಕ್ವಾಲಿಟಿ ಬಿಫೋರ್ ಲಾ ಅಂಡ್ ಈಕ್ವಲ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಫ್ ಲಾ ಯಾವ ರೀತಿ ಇದು ವರ್ಕ್ ಆಗುತ್ತೆ ಅನ್ನೋದನ್ನ ಒಂದು ಸಣ್ಣ ಚಾರ್ಟ್ ಮಾಡಿದೀನಿ. ಅದೇ ನಾವು ಈಗಲೇ ನೋಡಿದ ಹಾಗೆ ಈಕ್ವಾಲಿಟಿ ಬಿಫೋರ್ ಲಾ ಇಸ್ ಎ ಇಂಗ್ಲಿಷ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಂಡ್ ಈಕ್ವಲ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಫ್ ಲಾ ಇದು ಬಂದು US ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇಂದ ನಾವು ಇದನ್ನ ಅಡಾಪ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದು. ಈಕ್ವಾಲಿಟಿ ಬಿಫೋರ್ ಲಾ ಅಂತಂದ್ರೆ ಸ್ಟೇಟ್ ಕೆನಾಟ್ ಡಿನೈ, ಯಾರು ಕಾನೂನಿನ ಮೊರೆ ಎಲ್ಲರಿಗೂ ಈಕ್ವಾಲಿಟಿ ಅದ ಸಮಾನತೆಯನ್ನು ಕೊಡುವಂತಹ ಬಾಧ್ಯತೆ ಸ್ಟೇಟ್ಗಿದೆ ಅನ್ನೋದು ಈಸ್ ಈಕ್ವಾಲಿಟಿ ಫಾರ್ ಲಾ. ದಟ್ ಮೀನ್ಸ್ ನೋ ಅನ್ಈಕ್ವಲ್ ಪರ್ಸನ್ ವಿಲ್ ಬಿ ಟ್ರೀಟೆಡ್ ಅನ್ಈಕ್ವಲಿ. ಯಾರ್ಯಾರು ಸಮವಾಗಿರ್ತಾರೋ ಅವ್ರೆಲ್ಲರನ್ನು ಸಮಾನತೆಯಿಂದ ನೋಡುವಂಥದ್ದೇ ಈಕ್ವಾಲಿಟಿ ಬಿಫೋರ್ ಲಾ. ಈಕ್ವಲ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಫ್ ಲಾಸ್, ಇದು ಅಮೆರಿಕನ್ ಕಾನ್ಸೆಪ್ಟ್. ಇದನ್ನ ಸ್ವಲ್ಪ ನಾವು ನಿಧಾನವಾಗಿ ನೋಡಿದ್ರೆ ಯು ವಿಲ್ ಸಿ ಅ ಸ್ಮಾಲ್ ಡಿಫರೆನ್ಸ್ ಬಿಟ್ವೀನ್ ದ ಟು. ಈಕ್ವಾಲಿಟಿ ಬಿಫೋರ್ ಲಾ ಈಸ್ ಮೋರ್ ಆಫ್ ಅ ನೆಗೆಟಿವ್ ಕಾನ್ಸೆಪ್ಟ್, ಅಂದ್ರೆ ಒಂದು ನಕಾರಾತ್ಮಕವಾದಂತಹ ವಿಚಾರ ಅಷ್ಟೇ. ಇಟ್ಸ್ ನಾಟ್ ಲೈಕ್ ಎ ನೆಗೆಟಿವ್. ಈ ಕೆಲವೊಂದ್ಸತಿ ನಾವು ಇದನ್ನ ನೆಗೆಟಿವ್ ಆಗಿ ಯಾರಾದ್ರೂ ತಪ್ಪು ಮಾಡಿದ್ರೆ ಅವ್ರು ತಪ್ಪು ಮಾಡಿದ್ರಿ, ಅವ್ರನ್ನ ಬಿಟ್ಬಿಟ್ರಿ, ಅದಕ್ಕೆ ನಮ್ಮನ್ನು ಹಿಡಿತಾ ಇದ್ರ. ನೋ, ನಾಟ್ ಲೈಕ್ ದಿಸ್. ಇಟ್ಸ್ ನಾಟ್ ಸೀಕಿಂಗ್ ನೆಗೆಟಿವ್ ಈಕ್ವಾಲಿಟಿ, ನಕಾರಾತ್ಮಕವಂತ ವಿಚಾರ ಅಷ್ಟೇ. ವೆರಾಸ್ ಈಕ್ವಲ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಫ್ ಲಾ ಮೀನ್ಸ್ ದ ಸ್ಟೇಟ್ ಡಸ್ ಸಮಥಿಂಗ್ ಟು ಟ್ರೀಟ್ ಎವ್ರಿವನ್ ಈಕ್ವಲ್. ಈಗ ಉದಾಹರಣೆಗೆ ನಾವು ನೋಡೋಣ, ಒಂದು ಕಾಲೇಜ್, ಅದರಲ್ಲಿ ದೇರ್ ಈಸ್ ಎವ್ರಿವನ್ ಹೂ ಈಸ್ ಎಲಿಜಿಬಲ್ to take an admission have to be given admission in that college. Now let us say a rule is made that persons or children of persons who are working in the college will have a right to join the college without having any eligible criteria. Now, would this be a violation of principles of equality? It would certainly be a violation of principle of equality, because the classification that you have made has no nexus to the object that you have sought. But when you look at it positively, then it says in order to give equal protection, you can make a classification so as to meet the object. ಈಗ ಉದಾಹರಣೆಗೆ, in the class of 50, we will reserve certain seats for economically backward students. Now, students of economically backward, or students coming from district areas, or students coming from mainstream areas, ಇವರೆಲ್ಲರೂ ಸಮಾನರು. As students, they are all same, but they are unequal insofar as their background is from where they are coming. So in order to make equality for this, you introduce something. That means you make a classification so that you bring about equality among all of them. That means you give them equal opportunity. ಈಗ ಎಲ್ರಿಗೂ ನೀವು the class fare fees is only 10,000 rupees ಅಂತ ನೀವು ಇಟ್ಕೊಂಡ್ರೆ, person only who can afford that 10,000 rupees only will be able to take admission in that class. So you are then treating another person unequally, though he is eligible to take admission. So in such circumstances, you bring in some kind of a classification so that you give equality to persons who are unequal otherwise. But because of what the state does, they get equal protection of the law. So this is the concept of equality before law and equal protection of law. I hope you are able to understand this. Now, in order to write this, if what are the essential elements of Article 14 ಅನ್ನುವಂತ ಪ್ರಶ್ನೆ ಬರಬಹುದು. So the essential elements of Article 14 is that one, it applies to everyone and not only limited to citizens. So any resident or any person who is within the territory of India has a right to seek for equality before the law and equal protection, equally in all aspects. And if there is any inequality, in order to make the inequality become equal, state can make an intelligible differentia or make a classification so as to serve the proper object, that is object which are given in the constitution, to make unequals equals. So ಈ ರೀತಿ ಒಂದು ಈ ಪ್ರಶ್ನೆಗೆ ನಾವು ಉತ್ತರಿಸಿದ್ರೆ ಅದು ಸರಿಯಾಗಬಹುದು ಅಂತ ನನ್ನ ಅಭಿಪ್ರಾಯ. ಕೇಸ್ ಲಾಗಳನ್ನು ನೋಡೋಣ. ಈ ಇಂಟೆಲಿಜಿಬಲ್ ಡಿಫರೆನ್ಷಿಯಾ ಅನ್ನೋದನ್ನ ನಾವು ಸ್ಟೇಟ್ ಆಫ್ ಬಾಂಬೆ ವರ್ಸಸ್ FN ಬಲ್ಸಾರ AR 1951 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 318, ಇದರಲ್ಲಿ so long as there is a rational nexus to the object, they say you can make a intelligible differential. Next, EP Royappa versus state of Tamil Nadu, it says that equality has to go on evolving and it keeps changing, and based on requirement and public needs, you will have to see how this equality principle will flow. Now, apart from these two concepts, from Menaka Gandhi's case, there were two other concepts that were introduced. They said any action of the state, even if it is an arbitrary action, that would by itself amount to being a violative of Article 14. ಅಂದ್ರೆ ಈಗ ಸ್ಟೇಟ್ ಏನಾದರೂ ಆಕ್ಷನ್ ಮಾಡಿದ್ರೆ ಅದು ಅಷ್ಟು ತದ್ವಿರುದ್ಧ ಇದೆ. ಇಟ್ ಇಸ್ ಸೋ ಆರ್ಬಿಟ್ರರಿ ದಟ್ ಇಟ್ ಸೆಲ್ಫ್ ನೀವು ಅದನ್ನ ನನಗೆ ಇದರಿಂದ ನನಗೆ ಅನ್ಇಕ್ವಲ್ ಆಗಿದೆ ಅಂತ ಹೇಳೋ ಅವಶ್ಯಕತೆನೇ ಇಲ್ಲ. ಇದು ಆರ್ಬಿಟ್ರರಿ ಇದೆ ಅಂತ ತೋರಿಸಿದ್ರೇನೆ ಸಾಕು, ದಟ್ ಇಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಅಮೌಂಟ್ಸ್ ಟು ಇಟ್ ಬೀಯಿಂಗ್ ಇನ್ಫ್ರಿಂಜಿಂಗ್ ದಿ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ ಆಫ್ ದ ಪರ್ಸನ್ಸ್ ಅನ್ನೋ ತರ ಒಂದು ಈ ಮೇನಕಾ ಗಾಂಧಿ ಕೇಸಲ್ಲಿ ಹೇಳಿದೆ. ಸೊ ನಾವು ಐ ಮೇಡ್ ಅ ಸ್ಮಾಲ್ a chart. So all elements, whatever I have said there, all the 5-6 elements, if you are going to get a question with regard to Article 14, then one is what I said just now, you can answer in that way, the 3 elements, and this is how it works. Or you can say, through evolution and interpretation of the case laws by the Honorable Supreme Court, equality under Article 14 means all of these things. That is equal protection of law, equality before law, and natural justice, that no arbitrariness in the action of the state, and that the state is required at all points of time to follow rule of law. Idu 5 ತತ್ವಗಳನ್ನು ಅಥವಾ 5 ಅಂಶಗಳನ್ನು ನೀವು ಬರೆದ್ರೆ each one of it. Of India, so Air India versus Nargesh Mishra ಅನ್ನುವಂಥದ್ದು, ಹೆಣ್ಮಕ್ಳು ಮದುವೆ ಆದ ನಂತರ ಏರ್ ಹೋಸ್ಟೆಸ್ ಆಗಕ್ಕೆ ಅರ್ಹರಲ್ಲ ಅನ್ನುವಂತ ಒಂದು ಡೈರೆಕ್ಷನ್ ನ ಏರ್ ಇಂಡಿಯಾ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ. ನಾವು ವೆದರ್ ದಿಸ್ ಈಸ್ violative of Article 16, also whether it is violative of Article 14, it's very easy. The classification making between men to the job that they are doing. Now, a married air hostess can also perform the same job as an unmarried air hostess. So, it is not an intelligible classification. And then there is also a gender inequality there. So, Article 15, 16 and 14 ಗೆ ಒಳ್ಳೆ ಎಕ್ಸಾಂಪಲ್ ಅಂದ್ರೆ ಏರ್ ಇಂಡಿಯಾ ವರ್ಸಸ್ ನರ್ಗಿಶ್ ಮಿಶ್ರಾ, ಇದನ್ನ ನೀವು ತಗೋಬಹುದು. ಇನ್ನು ಆರ್ಟಿಕಲ್ 16 4A 4B ಪ್ರೊವೈಡ್ಸ್ ಫಾರ್ ರಿಸರ್ವೇಶನ್ ಆಫ್ ಬ್ಯಾಕ್ವರ್ಡ್ ಕ್ಲಾಸಸ್. ಇದು ಈಕ್ವಲ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಫ್ ಲಾಗೋಸ್ಕರ. ಈಗ ಹಿಂದುಳಿದವರಿಗೆ ನಾವು ಹೇಗೆ ಮುಂದೆ ತಗೊಂಡ್ಬರ್ತೀವಿ. ಸೊ ದ ಸ್ಟೇಟ್ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಪರ್ಫಾರ್ಮ್ ಸಮ್ ಆಕ್ಷನ್, that means make some reservation or give them some additional incentives so that they can become equal with others. So that 16, 4A and 4B in consonance is the classic example for equal protection of law. Illondu Indira Shane case barutte. This is recent. So it so happened in this case that in order to implement the Mandal Commission, it was seen that the report said that almost 52% of the Indian population were economically or otherwise backward. So, ಈಗ ರಿಸರ್ವೇಶನ್ ಕೊಡ್ಬೇಕಂದ್ರೆ ಎಲ್ಲ 52% ರಿಸರ್ವೇಶನ್ ಕೊಟ್ರೆ, then the whole concept of equal protection of law is of no meaning. ಎಲ್ರಿಗೂ ರಿಸರ್ವೇಶನ್ ಕೊಟ್ರೆ ಯಾವ ರೀತಿ equal protection of law ವರ್ಕ್ ಆಗುತ್ತೆ? So it is ಒಂಥರ ತದ್ವಿರುದ್ಧ. The effect will be totally opposite. So therefore, the Supreme Court said the reservation also cannot be stretched so much. So the 16 is a very classic example to say that the object of reservation should be that you bring the person who is truly in the backward to be equal with everyone else who are supposed to be socially forward. But you cannot bring the entire population as calling them as backward. Then the whole concept of 14 itself will become odious or it will become redundant. So even though idr mele they said that reservations so provided under the Money Commission cannot be implemented. So this is a clause for 16. So in Article 1718 is abolition of untouchability and abolition of titles. Illi titles andre apart from what is given, conferred by military or by distinction through your education, conferred by the state, distinction which the state gave us, like a doctorate. So these will be, other than these titles, no citizen is to claim or accept any title from anyone else or carry that title as a suffix to your name. So these two important things, one is untouchability abolition and abolition of titles. So that this is also again to go to show that we are trying to bring everybody under the one umbrella. So ಮುಖ್ಯವಾದ ಇದು freedom, fundamental freedoms ಅನ್ನೋ ಬಗ್ಗೆ ಮಾತಾಡೋಣ. There are 7 fundamental freedoms. One is now no longer there. So freedom of speech and expression. This would include freedom of press. Now freedom to assemble peacefully and without arms. Then freedom to form association or unions. Then freedom of movement. Freedom to reside in any part of India. And freedom to carry on trade, business and profession. Friends, let me tell you that each of these freedom has got its own restrictions. So what I've done, I've just made a small chart so that you see what the freedom is and whatever is the restriction under that. So 19(1)(a), speech of expression, freedom of speech and expression. Okay, this includes right or a freedom to receive any information. If you WhatsApp alli estondu information ಓಡಾಡ್ತಾ ಇರುತ್ತೆ, you have a right to get it. Plus, you also have a right to express those freedom, those ideas or those thoughts or those informations. Then you also have a right to remain silent or withhold it. In subtle newspapers, it was held that in this freedom of speech and expression, freedom of press is also a species of it that includes as the 5th limb of the freedom or fundamental rights. And that is how this freedom of press came to be put in one of the freedoms. Now, with the restrictions, you have a power, right to receive information. You have a right to share that information, share your thoughts. But these comes under specific restrictions. The restrictions that itself is put in Article 19(2). So that is restriction in the interest of sovereignty and integrity of India, to the security of the state and public order, then friendly relationship with other foreign countries. If you have a difficulty, for example, when we are having a friendly relationship with something, the state can say, put an embargo or put a restriction on the press that it cannot publish anything to do with these. So whether it becomes a reasonable restrictions or not. So long as it comes within the restrictions as specified, then it becomes a reasonable restrictions. Then a restriction to maintain decency and constitutional morality. For that, there can be restrictions. Then you have, for contempt of court is one of the restrictions. If anything that is said, that means your ideas or thoughts that you express, if it amounts to contempt of court, then that is one of the reasonable restrictions or action can be taken against you for doing that. So this is for 19(1)(a). 19(1)(b) nodana. So 19(1)(b) is gump serodu, to assemble peacefully and without arms. So these are the 2 basic conditions. Whatever assembly you want to do, you can do, but it has to be a peaceful. Nevenadru march, morcha en mardu idella peaceful agi madbeku annuvantaddu, with permissions from the concerned authorities. Now, any unlawful assembly, illegal possession of property, criminal trespass, preventing legal process, use of force on public officer, use of force on common man, taking law into own hands. These are all considered to be unlawful assemblies. So by its very nature, for example, if you want to create a strike, you want to carry arms and go around the roads of the city, then by itself, it is considered to be an unlawful assembly. Other than that, the state can impose restrictions for in the interest of sovereignty and integrity of the country and for public order. So for public order, the state can impose a restriction saying that we will not allow you to have assemblies. Now this restriction is different than then you do not having a right for an unlawful assembly. So unlawful assembly andre ಅಂಕಿತವಾಗಿಟ್ಟಿದ್ದೀನೋ ಇದೆಲ್ಲವೂ ನೀವು ಮಾಡಿದ್ರೆ ಇದು ಅನ್ಲಾಫುಲ್ ಅಸೆಂಬ್ಲಿ ಆಗುತ್ತೆ. ಸೊ ಒಂದ್ ಕಡೆ ಸ್ವಾತಂತ್ರ್ಯ ಇದ್ರೆ ಇನ್ನೊಂದ್ ಕಡೆ ಅದರದ ಬಾಧ್ಯತೆ ಕೂಡ ಇರುತ್ತೆ. ಒಂದೊಂದು ಸ್ವಾತಂತ್ರ್ಯಕ್ಕೆ ಒಂದೊಂದು ಬಾಧ್ಯತೆಗಳಿದೆ. ಅದೆರಡೂ right hand side you can see, left hand side you can see the freedom, on the right hand side you will see the restriction for each and every freedom that you have. Then you have 19(1) to form association, to take part in the same. So these includes trade unions, companies, partnerships.
Madam, one ನಿಮಿಷ ನೋಡಿ, ಅವನು ಯಾರ ಮುನ್ರಾಜು ಅಂತ ಗೀಚಿದಾನೆ. ನೀನ್ ಯಾವ ಸೀಮೆ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಆಗಕ್ ಬಂದಿದ್ಯಾ ಇಲ್ಲಿ ನೀನು? ನಾನು ಎಷ್ಟು ಸರಿ ಎಲ್ಲರಿಗೂ ಮುಂಚೆನೆ ಹೇಳಿದೀನಿ, ಯಾರಾದ್ರೂ ಗೀಚದ್ ಮಾಡ್ರೆ ಒದ್ದು ಆಚೆ ಕಡೆ ಹಾಕ್ಬಿಡಿದ್ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಇದು ಅಂತ. ಯಾರು ಗೀಚಿದಾರೆ ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ ನಮ್ಗೆ. ನಿಮ್ ನಂಬರ್ ತಗೊಂತೀನಿ, ನಿಮ್ಗೆ ಒದ್ದು ಆಚೆ ಕಡೆ ಹಾಕ್ತೀನಿ. ಆಮೇಲೆ ಅವನು ನಂಬರ್ ತಗೊಂಡು ಶುರು ಮಾಡ್ತೀನಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅವನ ಮೇಲೆ. ಯಾರಾದ್ರೂ ಗೀಚದ್ ಮಾಡಿದ್ರೆ ಇವಾಗ್ಲೇ ಹೇಳ್ರಿ, ಬಾರ್ ಕೌನ್ಸಿಲ್ ಇಂದ ನಿಮ್ಗೆ ಬಲಿ ಹಾಕ್ಬಿಡ್ತೀವಿ ನಾವು. ಮೇಡಮ್ ಈಗ ರೀಸ್ಟಾರ್ಟ್ ಮಾಡಿ ಅವ್ನು ಒದ್ದು ಆಚೆ ಕಡೆ ಹಾಕ್ತಾರೆ. ಅವ್ನು ಯಾರ ಮುನ್ರಾಜು ಅಂತೆ, ಅಯೋಗ್ಯರು ತಗೊಂಬಂದು.
So you want me to
ಅಲ್ಲ ರೀಸ್ಟಾರ್ಟ್ ಮಾಡಿ.
ಓಕೆ, ಸೊ ಸ್ಕ್ರೀನ್ ಶೇರ್ ಮತ್ತೆ ಮಾಡೋಣ ಅಂತೀರಾ?
ಯಾರಾದ್ರೂ ಗೀಚಿದ್ರೆ
ಸೊ ನಾನು ಇವಾಗ ಸ್ಟಾಪ್ ಮಾಡ್ತೀನಿ.
ಹಾಕ್ಬಿಡ್ತೀನಿ, ಇವಾಗ್ಲೇ ಹೇಳಿರ್ತೀನಿ. ನೀವು ಜಡ್ಜ್ ಆಗಕ್ ಬಂದಿದ್ರ ಅಯೋಗ್ಯರು ತಗೊಂಬಂದು ಹೊಸ್ತಾಗ್ ಹಾಕಿ ಮೇಡಮ್. ಸ್ಕ್ರೀನ್ ಶೇರಿಂಗ್ ಹೊಸ್ತಾಗ್ ಮಾಡಿ, ಇನ್ನೊಂದ್ಸರಿ ಮಾಡಿ.
ಓಕೆ, ಸೊ I'm going to restart it all over. Okay, so I hope everybody is with us except a few of these difficulties that will come. ಎಲ್ಲದಕ್ಕೂ ಅದನ್ನ ಹೇಳ್ತಾರಲ್ಲ
ನೋಡಿ, ಸ್ಟ್ರೆಂತ್ ತುಂಬಾ ಚೆನ್ನಾಗಿದೆ. ಎಲ್ಲರೂ ಅಚ್ಚುಕಟ್ಟಾಗಿ ಕೇಳ್ತಾರೆ. ಅವನ್ ಯಾರೋ ಮುನ್ರಾಜು ಅಂತ. ಯಾರಾದ್ರೂ ಮತ್ತೆ ಗೀಚಿದ್ರೆ ಇವಾಗ್ಲೇ ಹೇಳಿರ್ತೀನಿ, ನಿಮ್ ಹೆಸರು ಗೊತ್ತಾಗ್ತದಲ್ಲ ಯೂಟ್ಯೂಬ್ ನಲ್ಲಿ. ನಿಮ್ಗೆ ಏನ್ ಕ್ರಮ ತಗೋಬೇಕು ಅಂತ ಗೊತ್ತಿದ್ದು. ಬಾರ್ ಕೌನ್ಸಿಲ್ ಇದು ಯಾರೋ ಕಾಂಜಿ ಪಿಂಜಿಗಳು ನಡೆಸ್ತಾರದಲ್ಲ, ಇದು ಸೆಮಿನಾರ್. ಇವಾಗ್ಲೇ ಹೇಳಿರ್ತೀನಿ. ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಮೇಡಮ್.
ಥ್ಯಾಂಕ್ ಯು. ಒಂದೆರಡು ನಿಮಿಷ ಕೊಡ್ಬೇಕಾಗತ್ತಾ? ಜಸ್ಟ್ ಯಾ ಓಕೆ, ಸೊ ನಾವ್ ಇಲ್ಲೇ ಇದ್ವಲ್ಲ.
ಹೌದು.
ಸೊ ವಿ ವರ್ ಅಟ್ to form associations and take part in the same. So we have a right to freedom to trade union. ಅದಕ್ಕೆ ಆದಂತ ಒಂದು ಬಾಧ್ಯತೆ ಇದೆ. ಏನೇನ್ ಬಾಧ್ಯತೆ? Restriction in the interest of sovereignty and integrity of the nation. Then public order and authority. In All India Bank Employees Association ಅಲ್ಲಿ they've said that though you have a right to form associations or trade unions, you do not have a right to go on strike. So ನೀವು ಸ್ಟ್ರೈಕ್ ಬಂದು ಇದನ್ನೆಲ್ಲ ನೀವು ರೈಟ್ ಟು ಫ್ರೀಡಮ್ ಟು ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆರ್ ಫ್ರೀಡಮ್ ಟು ಮೇಕ್ ಟ್ರೇಡ್ ಯೂನಿಯನ್ಸ್, ಅದ್ರೊಳಗೆ ಇದನ್ನ ನಾವು ರಿಸ್ಟ್ರಿಕ್ಷನ್ ಆಗಿ ಹಾಕ್ಬೋದು. ಅಂಡ್ ದ ಕೋರ್ಟ್ಸ್ ಹ್ಯಾವ್ ಹೆಲ್ಡ್ ದಟ್ ದೀಸ್ ಆರ್ ಇನ್ಬಿಲ್ಟ್ ರಿಸ್ಟ್ರಿಕ್ಷನ್ಸ್. ನೀವು ಸ್ಟ್ರೈಕ್ ಅದು ಮಾಡುವಾಗಿಲ್ಲ ಅಂತ. ಸೊ ಮತ್ತೆ ಹೇಳ್ತೀನಿ, ಎಡಗಡೆ ಬರ್ತಕ್ಕಂಥದ್ದು ಫ್ರೀಡಮ್, ರೈಟ್ ಸೈಡ್ ಆಫ್ ದಿಸ್ ಕಾಲಮ್ ಏನ್ ನೋಡ್ತೀವಿ ಆ ಫ್ರೀಡಮ್ಗೆ ಅನುಗುಣವಾಗಿ ಇದು ಬಂದು ರಿಸ್ಟ್ರಿಕ್ಷನ್ಸ್ ನಾನು ಬರ್ದು ಹಾಕಿದ್ದೀನಿ. ಸೊ ದಟ್ ನಿಮ್ಗೆ ಇದನ್ನ ನೋಡಿ ನೀವು ಇದನ್ನ ಅಬ್ಸರ್ವ್ ಮಾಡ್ಕೊಂಡು ಈ ಪ್ರಶ್ನೆಗೆ ನೀವು ಸೂಕ್ತವಾಗಿ ಉತ್ತರ ಕೊಡಬಹುದು, ನಿಮ್ಗೆ ಸುಲಭವಾಗ್ಲಿ ಅನ್ನೋಂತ ಒಂದು ದೃಷ್ಟಿಯಿಂದ. ಸೊ ನೆಕ್ಸ್ಟ್ ಫ್ರೀಡಮ್ ಇಸ್ 19(1)D and 19(1)E to move from one state to another and to reside in any part of India. ಸೊ ಇದಕ್ಕೆ ಸೂಕ್ತವಾಗಿ ರಿಸ್ಟ್ರಿಕ್ಷನ್ಸ್ ಇರೋದು. Interest of the general public, you cannot move from one state to another. In the interest of general public, ಈಗ ಇತ್ತೀಚೆಗೆ COVID noted that we couldn't move from one state to another. So when there is health, safety, public, then state can put restrictions on our freedom of movement. This is a very unique, so each schedule can be restricted not to move from one place to another, so that their whole characteristics should not be lost. So from that angle, they can put restrictions to protect these scheduled tribes. State can put restrictions over the freedom of these scheduled tribes to move from one. This is the essential freedom or the basic freedom among the freedoms that we have under 19 anta ನಾವು ಭಾವಿಸಬಹುದು. Freedom to practice any profession, carry on any occupation, trade or business. ಇದರಲ್ಲಿ ನಾವು ಕಾನೂನು ರೀತಿಯಿಂದ interest of general public relating to professional or technical qualifications. Like for example, ನೀವು ವಕೀಲರಾಗಬೇಕು, ನಾಳೆ ಜಡ್ಜಸ್ ಆಗಬೇಕು ಅಂತಂದ್ರೆ ಅದಕ್ಕೆ ಆದಂತ restrictions na, though you have a freedom to practice any profession that you want, the state also has a power to impose any restrictions for this, for smooth functioning, or that it should come, that it should go in a natural way. So aa riti enadru restrictions na hakbodu, provided it comes within the restrictions as stated in 19(6) for 19(1)(g). Article 20 applies to all persons. Violation of law, and if it's so, any conviction without violation of law is an offense. And the offense should be, a conviction should be for an offense which is an offense at the time when it was committed. Next, penalty cannot be greater than what is prescribed in the law at the time of commission of offense. So this is Article 21. 20 sub-article 1. Then you have 20 sub-article 2. No prosecution or punishment for the same offense more than once. So ಇದಕ್ಕೆ ನಾವು double jeopardy ಅಂತ ಒಂದು ಸರಳ ಭಾಷೆಯಲ್ಲಿ ಹೇಳ್ತೀವಿ. Article 23. No accused shall be witness against himself. So criminal practice ಮಾಡಿದವರಿಗೆಲ್ಲ you will know very much about these. So these are the next ಇದು ಬಹಳ ಮುಖ್ಯವಾದಂತ ಆರ್ಟಿಕಲ್, right to life and personal liberty. So this article says no to procedure established by law. So life has various components. It has got from dignity, reputation, good living, healthy living, good. Dignity and reputation is like salt, like how salt is to food. Dignity and reputation is for life. So dignity, living with dignity, living with reputation. So these are all a part of right to life. So whether right to life includes right to die, for that said, no, we will see that also. Personal liberty andre enu? Personal liberty has evolved in the past many years, right from 1950 to 70. ಅಂದ್ರೆ ಯಾರಾದ್ರೂ ನಿಮಗೆ ಫುಲ್ ಕೋರ್ಷನ್ ಅಥವಾ ಜಬರ್ದಸ್ತಿಯಿಂದ ಏನಾದ್ರೂ ಮಾಡಿದ್ರೆ ಆವಾಗ ಮಾತ್ರ courts would consider it to be a violation of your personal liberty. But recent years, we have seen this right has evolved over a long period. It has evolved so beautifully that now we see that any preventive detention also is considered to be a violation of personal liberty. And then we also see that slowly courts have various, at many times, given bail is the rule and not the jail. So this is also an evolution of the personal liberty rights. And any deprivation has to conform with justice and fair play. And the present view, it says that even right to travel, right to speedy justice, right to meet family and friends. So these are also as being taken by the courts to mean personal liberty. And Recently, we have all seen Kutswami judgment ali, right to privacy is also taken to be as a right of personal liberty. But when there is a conflict of personal liberty between two individuals, then what happens? So it says the one that advances public morality should prevail over the other's personal liberty. So ee eradu right ge, that is life and personal liberty ge, has to, if there is any restriction on that, that has to be only through a procedure established by law. Now, what is this procedure established by law? Again, earlier it said any law which said yes, I can put an embargo, that would suffice. But now, as we have evolved, we have seen the procedure should not only be just having a power to put the procedure should not be arbitrary, should be fair and reasonable. So it cannot be any executive orders or departmental instructions. There has to be a statutory authority or a statutory basis which will give the executive that power to pass, to show the liberty that it has taken away is in accordance with the procedure established by law. And whether article gets suspended when emergency is imposed under Article 359, the answer is no. No doubt this was because of 44th Amendment of Constitution. So, 44th Amendment kina madlu. Is that so? Yes. In ADR Jabalpur case ali, emergency bandaga Article 21 was also suspended. That time the court held that under 359, if all fundamental rights can be suspended by imposition of emergency under 359, it would also include Article 21, annuvanta in declaration of law. It was very unfortunate. Adanna 44th Amendment to Janata Government or adanna repeal madi, all other fundamental rights can be curtailed or get suspended, but Article 21. So now note that Article 21 is slowly taking over. ಇಡೀ ಫಂಡಮೆಂಟಲ್ ರೈಟ್ಸ್ ಜೀವಾಳ ಆಗ್ತಾ ಇರೋದನ್ನ ನಾವು ಕ್ರಮೇಣ ಇಲ್ಲಿ ನೋಡ್ತಾ ಇದ್ದೀವಿ. ಕೆಲವೊಂದು ಕೇಸ್ ಬಗ್ಗೆ ನೋಡೋಣ. ಮೊಟ್ಟ ಮೊದಲ ಕೇಸ್ ಓಪನ್ ದಿ ಐ ಅಂತ ನಾವು ಹೇಳಿದ್ರೆ, ಈ ಹಳೇ ಥಿಂಕಿಂಗ್ ದಟ್ ಈಸ್ ಓನ್ಲಿ ಬಿಹೈಂಡ್ ಜೇಲ್, that your article, your right to life ಅನ್ನುವಂತ ಏನು ಮೊದಲು ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಇತ್ತು 1915 ಅದು ಕ್ರಮೇಣ ದ ಟೆಸ್ಟ್ ಆಫ್ ವಿಸ್ಡಮ್ ಕಾನೂನು ಏನು ಅಥವಾ ಏನು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡುತ್ತೋ ದಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಫೇರ್ ಅಂಡ್ ಜಸ್ಟ್ ಅಂಡ್ ರೀಸನಬಲ್, ವಾಟ್ ಎವರ್ ಇಟ್ ಕುಡ್ ಬಿ. ಸೊ ಅನ್ಲೆಸ್ ಅಂಡ್ ಅಂಟಿಲ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಜಸ್ಟ್ ಫೇರ್ ಅಂಡ್ ರೀಸನಬಲ್, ಎನಿ ಆಕ್ಷನ್ which curtails any of the rights, that is right to travel, avagale nodri, right to travel, right to live in a good environment, right to water, right to be curtailed, it has to withstand the test of reasonableness annuvanta. This is the evolution that we have seen in Article 21. So I was telling you whether right to live includes right to die. This was answered in this year. You can see here they questioned section 309 of IPC as being violative of Article 21 because they argued to say that includes right to die also. For that, Supreme Court has not accepted that. It said right to live cannot contemplate or include within itself right to die. But however, it did ask the legislature to look into it. So ega the legislature has brought in the recent Mental Health Act, wherein it says yaradru attempt to suicide madkondre, then we can take that person to be of having a mental difficulty and then try to address that issue from a mental aspect and not so much from a offense aspect as to make it a criminal offense. So that's slow, but nevertheless 309 is not struck down, it is still there. Then one of the few ones that we have seen insofar as giving a better way of a neighborhood that you want to live. So non-adherence of zonal regulations or putting up industries in non-industrial areas would amount to infringement of article under 21. So illi of civil liberties, ಇದರಲ್ಲಿ ಟೆಲಿಫೋನ್ ಟ್ಯಾಪಿಂಗ್ ಅಂತ ಫೇಮಸ್ ಕೇಸ್ ಇದು. ಇದರಲ್ಲಿ we get right to by tapping their phones. Then in 1985, we have seen courts have said to an environment, right to good drinking water also is considered to be a right to life. ಇದು ನಾನು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದು. Due to bad condition of the streets amounts to violation of right under Article 21 of the Constitution ಅನ್ನೋದನ್ನ ಡಿಕ್ಲೇರ್ ಮಾಡಿದ್ದಾರೆ. ಈ ಕೇಸ್ ನಮ್ಮ ನಗರದಲ್ಲಿ ಎಲ್ಲ ಒಳ್ಳೆ ರಸ್ತೆಗಳಾಗ್ಲಿ ಅನ್ನೋಂತ ಒಂದು ಉದ್ದೇಶದಿಂದ ಹಾಕ್ತಾರೆ. Or if there are no good roads, it would amount to violation of Article 21 ಅನ್ನುವಂಥದ್ದು. So ಇಲ್ಲಿ I've given you the basic or right triangle. So if you have to ask or have a question, what are the fundamental rights under the Constitution? ಈ 3 ಆರ್ಟಿಕಲ್ ಬಗ್ಗೆ ನೀವು ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಬರೀಬಹುದು. Article 20. I have brought about few articles and made a small distinction between fundamental rights and human rights. These are articles comes under human rights. So ಮಾನವೀಯ ಹಕ್ಕುಗಳು ಯಾವುವು ಅಂತ. I don't know whether they'll ask such a question, but when if you want to answer it, innovatively, what are the fundamental so you can say these are the ಮಾನವೀಯ ಹಕ್ಕುಗಳು ಸಹ ಇದೆ ಅನ್ನುವಂಥದ್ದನ್ನ ನೀವು ಅದನ್ನ ಆ ರೀತಿ ಆನ್ಸರ್ ಮಾಡಬಹುದು. That will be an innovative way of doing, maybe it will be appreciated. So abolition of untouchability, protection of child labor, protection of human trafficking, and protection of dignity under Article 20. Slow, they are taking over to become as human rights under the Constitution. Article 6 ರಿಲಿಜಿಯಸ್ ಫ್ರೀಡಮ್ಸ್, ಇದ್ರ ಬಗ್ಗೆ ನಾವು ಇತ್ತೀಚಿನ ಕಾಲದಲ್ಲಿ ಸಾಕಷ್ಟು ಕೇಳಿದ್ದೀವಿ. ಇತ್ತಿನ ಡಿಸಿಷನ್ ವಾಟ್ can the state interfere with your religious rights or religious practice? Is a very dicey question. It's very difficult to
ಓಕೆ, ಸ್ವಲ್ಪ ಇಂಟರ್ನೆಟ್ ನಿಮ್ ಕಡೆಯಿಂದ ಸ್ವಲ್ಪ ಡೌನ್ ಇದೆ ಮೇಡಮ್. ನಿಮ್ಮ ಇಂಟರ್ನೆಟ್ ಡೌನ್ ಇದೆ ನಿಮ್ ಕಡೆ. ಅನುರಾಧ ಮೇಡಮ್, ಸ್ವಲ್ಪ ಇಂಟರ್ನೆಟ್ ಯಾಕೋ ಡೌನ್ ಇದೆ ಲಾಸ್ಟ್ 10 minutes ಇಂದ.
ಒಂದ್ ನಿಮಿಷ ಗೊತ್ತಾಯ್ತು.
The voice is dragging.
Okay.
ಸ್ವಲ್ಪ internet ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಅನ್ಸುತ್ತೆ. ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಬರ್ತಾ ಆಯ್ತಾ? ಇವಾಗ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಎಸ್ 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 ಎಸ್. ನಿಮ್ದು ವಿಡಿಯೋ ಸ್ವಲ್ಪ
ಪ್ರಾಬ್ಲಮ್.
ನಿಮ್ದು ವಿಡಿಯೋ
better?
Yes, yes, yes.
Now are we better?
Perfect, perfect.
I know. Okay. So let me try and see why this happened. Just a minute. Continue madna?
Kandita. Yes, yes.
Trying to see whether now my internet should be okay, I think.
Yes, yes.
So these are all technological hazards. So we'll have to bear with that. So dear friends, kindly bear with this. Ellaru ಸ್ವಲ್ಪ ಸಹಕರಿಸಬೇಕು. ಎಲ್ಲರೂ ಕೇಳಿಸ್ತಾ ಇದೆ ಅಂತ ನಾನು ಅನ್ಕೊಂತಾ ಇದ್ದೀನಿ. Is my screen share still on?
No, it's not on.
Okay. Yeah. Yeah. Can we see this now again?
Yes, yes, yes.
Yeah. Okay. So I was at, I'm just trying to see if I can shift to any other. So I don't think so that is possible. I think we will try to go ahead with this. So Article 25 and 26, ನಾನು ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೆ ಅಂತಂದ್ರೆ,
But you have a powerful internet ಅಲ್ಲ, ಯಾಕಂಗ ಆಗ್ತದೆ?
I don't know.
ನೀವು ಮೊಬೈಲ್ ಕನೆಕ್ಟ್ ಆಗಿದ್ದೀರಾ?
Fine actually, but I don't know why that is happening.
ಮೊಬೈಲ್ ಕನೆಕ್ಟ್ ಆಗಿದ್ದೀರಾ? You are using this Wi-Fi?
I'm using Wi-Fi. I'm not using mobile.
Okay, okay.
I am not able to use mobile also. But are we okay with this?
Yes, 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 yes. Now it's okay.
Yeah. Okay, okay. All right. So friends, I hope everybody is with me and you are able to see the screen share that I'm doing now again. Okay, so we were on article. Okay, so freedom of practice, freedom to practice and propagate religion. Am I audible?
Yes, yes.
Sorry, I don't know why we are having this little bit difficulty here. So ಇದರಲ್ಲಿ ಒಂದು ತಮಾಷೆ ಆದಂತ ಒಂದು ನಾವು ವಕೀಲರು ಮಾತಾಡ್ಕೊಳ್ತಾ ಇರ್ತೀವಿ. ಎಲ್ಲಿಗೆ ರಿಲಿಜಿಯಸ್ ಪ್ರಾಕ್ಟೀಸ್ ಶುರು ಆಗುತ್ತೆ, ಎಲ್ಲಿಗೆ ಎಂಡ್ ಆಗುತ್ತೆ, ಇದನ್ನ ಏನಾದ್ರೂ ನಾವು ವರ್ಣಿಸ್ಬೇಕು ಅಂತಂದ್ರೆ, ಈಗ ನಾವೆಲ್ಲ ದೇವಸ್ಥಾನಕ್ಕೆ ಹೋಗ್ತೀವಲ್ಲ, ದೇವಸ್ಥಾನದಲ್ಲಿ ಎಲ್ರು ತೆಂಗಿನಕಾಯಿ ತಗೊಂಡ್ ಹೋಗ್ತೀವಿ. ಸೊ ನಾವು ತೆಂಗಿನಕಾಯಿ ಖರೀದಿ ಮಾಡೋದು, ದೇವಸ್ಥಾನದ ಒಳಗೆ ಹೋಗಿ ಗರ್ಭಗುಡಿವರೆಗೂ ತೆಂಗಿನಕಾಯಿ ಏನ್ ಜರ್ನಿ ಇದೆಯೋ, that would be considered to be a secular part of the religion. Once the coconut or tenginkai is taken by the priest and he goes into the garbhagudi, and what happens there ಅದು ಮಾತ್ರ ರಿಲಿಜಿಯಸ್ ಪ್ರಾಕ್ಟಿಸ್. ಅಂಡ್ ಒನ್ಸ್ ಮತ್ತೆ ಅವನು ವಾಪಸ್ ತಂದು ಕೊಟ್ಟ ತಕ್ಷಣ then it becomes a back as a secular practice ಅನ್ನುವಂಥದ್ದು ನಾವು ಈ ಒಂದು ಸನ್ನಿವೇಶನ ತಗೊಂಡ್ರೆ then we can see that it is we can understand what religious and secular practice ಅನ್ನುವಂಥದ್ದು. So I'm just trying to see if I can become a better, no, I don't think so. So we will go ahead with this. So then we have Article 27, proceeds of any tax cannot be appropriated for maintenance and promotion of any particular religion. No, my screen share just went bad.
Now it's coming slowly.
No. There are two screen shares that have happened.
Now it's coming.
Yeah, okay. So we were at religious practice. I hope everybody could hear about the religious freedom that I spoke about. Now next, let us go to cultural and education rights. This is all under Article 29. So idralle mostly yav prashne kelalla anta nanna bhavane. ಆದ್ರೂ ನಿಮ್ಗೆ ಹಾಕಿದೀನಿ, ಅಕಸ್ಮಾತ್ ನೀವು ಇದನ್ನ ಉಪಯೋಗಿಸ್ಕೊಂಡು ಬೇರೆ ಯಾವ್ದಾದ್ರು ಫ್ರೀಡಮ್ ಅಥವಾ ರೈಟ್ ಗೆ ಸೇರಿಸ್ಕೊಂಡು ಹೇಳಕ್ಕೆ ನಿಮ್ಗೆ ಅನುಕೂಲವಾಗ್ಲಿ ಅನ್ನೋ ಒಂದು ದೃಷ್ಟಿಯಿಂದ ಇಲ್ಲಿ ನಾನು ಇದನ್ನ ಇಟ್ಟಿದ್ದೀನಿ. A, B and C ಇದನ್ನ ಈ ನಮ್ಮ ಕನೆಕ್ಷನ್ ಬೇರೆ ಸರಿ ಇಲ್ಲ, ಇದ್ರ ಬಗ್ಗೆ ಎಷ್ಟು ಮಾತಾಡೋಣ. What about it has in fact saved the constitution. The beautiful story for this, but ಈಗ ನಮ್ಗೆ ಕಾಲಾವಕಾಶದಿಂದ ನಾನು ಇಲ್ಲಿಗೆ ಹೋಗಲ್ಲ. ಇದು Article 32. In my opinion, Article 32 is a very unique article under the Constitution. So right to move the Supreme Court directly for enforcement of rights under okay. So Article 32.
ಕೇಳಿಸ್ತಾರೆ ಮೇಡಮ್?
Yeah. So Article 32 ಬಗ್ಗೆ ನಾನು ಮಾತಾಡ್ತಾ ಇದ್ದೆ. So Article 32 is a very unique article which is under the Indian Constitution. ಇದು ನಾವು ಬಹುಶಃ ಯಾವ ಬೇರೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಲ್ಲಿ ಇದನ್ನ ನಾವು ನೋಡಿಲ್ಲ ಅಂತ ನನ್ನ ಒಂದು ಭಾವನೆ. 32(1) is a right to move Supreme Court directly, and 32(2) is what are the powers of Supreme Court. Whenever you go to the court directly, it can issue all kinds of writs. Then 3, it says that Parliament confer power to any other court, and then it can also be suspended as provided under the Constitution. ಈ 32ನ ನಾವೇನಾದ್ರೂ ಜ್ಞಾಪಿಸ್ಕೋಬೇಕು ಅಂತಂದ್ರೆ ಇದಕ್ಕೆ ಒಂದು ಬ್ಯೂಟಿಫುಲ್ ಸ್ಟೋರಿ ಇದೆ. ನಮ್ಮ ಸಂಸ್ಕೃತಿನಲ್ಲಿ we say that a king always had a bell in front of his kingdom. ನೀವು ಮಡ್ರಾಸ್ ಹೈಕೋರ್ಟ್ಗೆ ಎಲ್ಲಾದ್ರೂ ಹೋದಾಗ ಇದೊಂದು ಚಿತ್ರ ಮೋಸ್ಟ್ಲಿ ಮಡ್ರಾಸ್ ಹೈಕೋರ್ಟ್ಗೆ ನೀವು ಹೋದಾಗ you can see there. Okay. You can see that there is a statue of Manunidhi Cholan. Am I audible? Yeah, voice is breaking and we cannot see. I will try to see if I can get into a better signal so that I can.
Okay.
Okay, friends, so we're not able to kind of see this. So what we will do, we will, for the time being,
Yes.
leave it. We'll leave the screen sharing for a minute. So I will just take it the way it is. I hope you're not seeing the screen share, right?
Screen share ಕಾಣಿಸ್ತಾ ಇಲ್ಲ.
ಅದಕ್ಕೆ ಬೇಡ ಅಂತ, because we can save the internet. So I'm just going to leave the screen share. So I was talking to you about Article 32. So Article 32 speaks about a unique right where you can go directly to the to the Supreme Court for violation of any of your constitution. Then next, I just want to talk to you about what is basic structure of the constitution. So basic structure of the constitution ನಲ್ಲಿ ಒಂದು ದೊಡ್ಡ ಹಿನ್ನೆಲೆ ಇದೆ. ಈಗ ಕಾಲಾವಕಾಶದಿಂದ I am not able to speak to you about it, but maybe you could make a small note. Basic structure of the constitution would be first the supremacy of the constitution. That constitution is the supreme. That is rule of law. Constitution is the supreme, and there is no one else other than the constitution. Idu antadana we can say that to be the one of first basic structure of the constitution. Then of course you have seen the preamble. Preamble is a basic structure of the constitution. Then the three organs, that is a federal structure of the parliament: legislative, executive, and judiciary. The federal structure of the constitution is also a basic structure of the constitution. Then universal adult franchise, then fundamental rights. These were all held to be the basic structure of the constitution in the famous Keshananda Bharati versus State of Kerala. Directive principles of state policy. ಇದರಲ್ಲಿ ಸಂಕ್ಷಿಪ್ತವಾಗಿ ಒಂದೊಂದಾಗಿ ಬರೀ ಹೇಳ್ತಾ ಹೋಗ್ತೀನಿ. These directive principles of state policy ಅಂತಂದ್ರೆ, these are the principles which the government is supposed to follow and make laws for achieving the goals of the constitution. So these are basically principles of governance. So one is, of course, to ensure justice, all social, economic, and political. Other now nodidvi. 39, Article 39 speaks about giving all of them adequate means of livelihood. Whatever all the natural resources of the community, that should be distributed in such a way that it is for everybody's common good. Ellargu ಒಳ್ಳೆದಾಗಲಿ ಅನ್ನೋಂತ ಒಂದು ದೃಷ್ಟಿನಲ್ಲಿ whatever is a natural resource of the country, ಅದನ್ನೆಲ್ಲ ನಾವು ಯಾವ ರೀತಿ ಅದನ್ನ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡ್ತೀವಿ. Then equal pay for equal work is one of the directive principles. Then development of children, then health and welfare and strength of the workers, they should not be abused. So idrinda. Then we had a 9039A, which speaks about giving justice and free legal aid. And establishment of panchayats comes under Article 40. Then Article 41 speaks about right to work, education, and public assistance. Then Article 42 speaks about giving good human conditions in work environment and also for maternity. Then among the rest, I could only now say that giving or looking forward to have a uniform civil code is one of the directive principles of state policy under Article 44. Then you have right to education under Article 45. Then protection and promotion of education and economic interest of weaker sections, both SC, ST and weaker section comes under Article 46. Then you have many other articles, that is, which comes for directive principles of state policy. Adralli antaddenu ನೀವು ಎಕ್ಸಾಮ್ ಅಲ್ಲಿ ಬರುವಂತದ್ದು ನನಗೇನು ಕಾಣಿಸ್ತಿಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಅಷ್ಟೊಂದು ಅದನ್ನ ತಗೊಳ್ತಾ ಇಲ್ಲ. ಇನ್ನು ಕೊನೆಯದಾಗಿ we will only speak about fundamental duties. So what fundamental duties ಅಂದ್ರೆ ಏನು? Fundamental duties are the duties which every citizen have to follow, or rather it is his ಅವ್ರ ಬಾಧ್ಯತೆ ಇದೆ, ಅದನ್ನ ಮೂಲಭೂತ ಕರ್ತವ್ಯಗಳು ಅಂತ ನಾವು ಹೇಳ್ಬೋದು. ಇದರಲ್ಲಿ ರೆಸ್ಪೆಕ್ಟಿಂಗ್ ದಿ national ideas, national flag, national anthem is one of the fundamental duty. Then we should cherish the struggle, the freedom struggle of our forefathers or freedom struggle people. Then to uphold and protect sovereignty and integrity is one of the duty of the citizen. Then to defend and render national service in all forms, that is one of our duty. Then to promote harmony and maintain brotherhood, to uphold the rich heritage of our country, and to safeguard public property. So it is one of our fundamental duty to safeguard public property. So these are the fundamental duties. So as I said, friends, the possible questions that may come is on preamble, on fundamental rights, basic structure, and at best, there could be a question leaving all this or just on directive principles of state policy coupled with fundamental duties. So in my thought process, I thought these are the ones possibly that if you could give your thought, ಇದನ್ನ ಒಂದ್ಸತಿ ನೀವು ನೋಡ್ಕೊಂಡ್ರೆ ಇದು ನಿಮ್ಗೆ ಸಹಾಯ ಆಗುತ್ತೆ ಈ ಎಕ್ಸಾಮ್ ಬರೆಯೋಕೆ ಅನ್ನೋ ಒಂದು ದೃಷ್ಟಿಯಿಂದ. ಇನ್ನು ನಾನು ನಿಮ್ಗೆ ಹೇಳ್ದಾಗೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇಸ್ ಅ ವೆರಿ ವಾಸ್ಟ್ ಸಬ್ಜೆಕ್ಟ್. ಇದರಲ್ಲಿ 1 hour ಅಥವಾ 1.5 ಗಂಟೆ ಅಥವಾ 4 ಗಂಟೆನಲ್ಲೂ ನಾವು ಎಲ್ಲಾನು ಅದನ್ನ ಸಂಘರ್ಷಿ ಮಾತನಾಡಕ್ಕೆ ಬಹಳ ಕಷ್ಟ ಆಗುತ್ತೆ. ಆದ್ರೂ ಏನ್ ಪ್ರಶ್ನೆ ಕೇಳಬಹುದು ಅನ್ನೋ ಒಂದು ದೃಷ್ಟಿಯಿಂದ ನಾನು ಊಹಿಸ್ಕೊಂಡು ಇದು ಇರಬಹುದು ಅಂತ ಇದನ್ನ ಮಾಡಿ ನಿಮ್ ಮುಂದೆ ನಾನು ತಂದಿಟ್ಟಿದ್ದೀನಿ. ನಿಮ್ಗೆಲ್ಲ ಇದರಿಂದ ಸಹಾಯ ಆಗಿದೆ ಅಂತ ನನ್ನ ನಂಬಿಕೆ. ಇನ್ನು ನಿಮ್ಗೆಲ್ಲ ಶುಭವಾಗ್ಲಿ, ಮಂಗಳವಾಗ್ಲಿ ಅಂತ ಹಾರೈಸ್ತಾ ನನ್ನ ಮಾತು ಮುಗಿಸ್ತೀನಿ. ನಮಸ್ಕಾರ. So I would thank each one of you for having joined this talk and for having heard me. So I hope this will help you and help you to answer the forthcoming examination.